I see two of you there, but I'm assuming one of you is going to make the argument, correct?
Oh, yeah, just me.
Okay, thank you. All right, we're ready.
Thank you. Good morning, Your Honors, and may it please the Court. David Zimmer on behalf of Mr. Rivera-Mendoza, and I'm going to try to reserve 2 minutes if I can. I want to sort of pick up on what Judge Rakoff was getting at, which is just that at a high level, when we think about crimes, we generally imagine one, if not both, of two things. One would be some sort of harm to the victim, and the other would be some sort of intent to harm the victim or engage in the conduct that is deemed wrongful by the statute. And what is really unusual about the type of negligent endangerment statute at issue in this case, like Oregon's, is it actually requires neither of those things. It doesn't require that the child be harmed in any way, and it doesn't even require that the defendant be aware that her conduct was putting the child at a risk of harm. And I think the Oregon Court of Appeals decision in Obeidi really makes both of those points really clear.
In that court, it held that the conviction under the statute required a showing that the risk of, quote, harm occurring was substantial and unjustifiable, unquote, and that defendants, quote, lack of awareness of that risk was a gross deviation from the normal standard of care, unquote. So how does that really differ from the mens rea of criminal negligence required by 1227?
Well, we don't think that that is the mens rea required by 1227. I mean, our whole point is that when you're interpreting a crime under the Supreme Court's decision in Ruan and applying ordinary tools of construction, that 1227 requires a higher mens rea, at least recklessness and maybe knowledge or intent. That's our argument in this case. We're not disputing that the Oregon statute requires a mens rea of negligence. That is the mens rea of the statute. But I think our point is that Obeidi highlights just how broad these negligence-based statutes are, where you have a mother who left her 1-year-old child in a car seat in a locked car to run into a store to buy diapers. And the Court of Appeals upheld the conviction based on the attenuated risk that the child might have been abducted while the mother was in the store. And even though it was basically undisputed at trial that the mother did not actually believe she was putting her children at a risk of harm. It was an objective standard that was imposed there. And you know, under the 10th Circuit's decision in Ibarra and under both the concurrences that were recently put out in the 11th Circuit Bastius decision, that type of negligence is not enough. And I'd really point the court in particular.
I don't know if they said that. I think just said they said as recklessness was the statute, and so you didn't have to go further. They didn't rule that criminal negligence was below the threshold.
Well, Judge Marcus explicitly interpreted the statute to require recklessness or more, so that we would win under that.
Right.
And Judge
but he didn't rule that below recklessness is outside of the statute.
I think he did. I mean, it wasn't because he interpreted that statute to require recklessness. Arguably, it was dicta. But I mean, when he describes the meaning of the statute, he says explicitly that it requires recklessness or greater. So, I mean, maybe that's dicta given the way he interpreted the Florida statute, but I think that was his interpretation. And Judge Newsom sort of said that the unmistakable upshot of applying the ordinary tools of construction was that even recklessness wasn't enough. And he also, of course, didn't reach it because of other reasons. But
you must know I joined Judge Collins' concurrence with Diaz-Rodriguez. Assuming I haven't changed my mind, I mean, is this issue closed for me?
So if you haven't changed your mind, it is an issue that is an issue that's closed for you. I'll be honest. But if you wouldn't mind, I'm going to at least take a shot at convincing you why you should change your mind.
Sure.
And I'll note that actually Judge Newsom changed his mind, right? So in the initial Bastius decision, he, just like Judge Collins, relied very heavily on the fact that neglect and negligence have the same underlying root and said that, well, therefore neglect must mean negligence. And we represent the petitioner in that case as well. And actually put before Judge Newsom on remand from the Supreme Court, before the whole panel, obviously.
Well, I think anytime we're talking about kids, you know, that we don't assume that parents or other people always know what, you know, what's safe for children. And so as a society, we're very protective of the most vulnerable not being subjected to a kind of behavior that puts them at risk. So it's different than when we're talking about mens res about adults a lot of times.
Well, and I think that's why there's a robust civil law that is intended to protect kids and that does have very broad definitions of these terms. But when you're talking about imposing criminal penalties on people for conduct that they didn't even understand to be wrongful, That's extremely
Does
unusual.
that make the kids more safe because their parents didn't know that what they were doing? Okay, so you send them out, no, and they can't swim, and you let them go into the pool, and you go in and.
Well, but
Yeah,
Your Honor, I guess
mean, it's like
sorry.
I think that's the whole idea that we're not counting on people having good judgment. We're counting on protecting children from bad judgment.
Right, and that's exactly what civil law does. And what criminal law does is it doesn't protect children. It imposes criminal penalties on people who do particularly extreme things. And that's exactly what the Supreme Court, not in the context of children, but if you look at the Supreme Court's decision in Rouen, it basically says explicitly that, that federal law almost never interprets crimes to have absent something explicit in the statute.
Well, I think the other circuits don't help your arguments here. The 4th in Cruz, the 5th with Sandoval, and the 11th with Bastias. I think they've held that 1227 encompasses child endangerment even when the child is not hurt. So why isn't that the best reading of the statute?
Well, we're not disputing that point, Your Honor. We're not actually arguing that there's a harm requirement. We're arguing that when you're talking about non-injurious conduct, negligence isn't enough. So I think, if anything, actually, it's the government's position in our case that would create a circuit split with the 10th Circuit's. It would clearly create a circuit split with the 10th Circuit's decision in Ibarra, and we think it would create a split. I mean, it's not as quite an outright split, but certainly in tension with the 2 recent concurrences in Bastias. And in fact, we don't see anything inconsistent. I mean, with Cruz, that wasn't a negligence case, and I agree you could sort of read it but I think that's dicta. I don't think there would be a conflict with Cruz to adopt our position. But if I could get back to the point, to answer the Judge Bumate's question, we put before the panel on remand the same definitions from Blacks and the same definitions from the other legal dictionaries that basically actually go out of their way to say that the word neglect does not imply negligence, that in fact these are different things. That doesn't answer the question at all. And Judge Newsom changed his mind, right? He actually, based on those arguments, and you can listen to the argument, we talked about this at length. We also pointed out that the contemporary state criminal codes in 1996, the ones that use the word neglect, almost none of them had a mens rea of negligence. They almost all had a mens rea of recklessness or higher. And so I actually think that there's really very little support for the idea that the word neglect itself, and that was the whole concurrence, right? And this didn't come up, in fairness, before in the briefing in that case. But basically, the whole reasoning in Judge Collins's concurrence as to why negligence was enough was that it was inherent in the word neglect. And I just respectfully, I don't think that's right. And again, Judge Newsom changed his mind on this exact point. And so, I'm not disputing that if you stick with that, we lose. Yeah. But we actually agree with almost everything in that concurrence, except for that, right? And it's an important point because that concurrence applies an objective rather than subjective standard. And if you look at Rouen, it's a pretty clear. I mean, this is a quote from Rouen. We have long been reluctant to infer that a negligence standard was intended in criminal statutes, and it goes on to explain that the reasonable.
Do you want to save 2 minutes to try to change his mind?
Sure, I'll save my remaining time. Thank you very much, Your Honor.
Okay, thanks.
Good morning, Your Honors. Me again, Imran Zaidi.
The same Mr. Zaidi.
The same
All
Mr.
right.
Zaidi.
Welcome back.
Thank you very much. I think I'll start with Obeidi because I think when we entered the conversation in a case like this, we're talking about negligent endangerment, which is, as I understand it, petitioner's only challenge. They don't really, despite all of the child endangerment is a separate crime arguments, they're not arguing that child endangerment is not included within the concept of child abuse. They're only arguing that you just need to lop off this concept of negligent endangerment, that somehow that makes it beyond the pale. And on that point, I'd like to make 2 broad points. One is about, again, criminal negligence, which I just spent some time talking about. This is not a standard that is just meant to encompass single one-time parent lapsing, walk out of the bedroom while the child's on the bed, walk into the store really quickly to get something while the child's in the car seat. This is not that standard. This is a gross deviation from a standard of care to a child, or standard of care in general, that creates a substantial and unjustifiable risk. So that's on the definition side of it. And then I also want to highlight how, in terms of the cases where it is applied, none of them reflect the types of circumstances where you think of it as a one-time parental lapse.
I think petitioners I think I'm understanding that saying that the Oregon statute covers not just a risk of harm, but a risk of harm. and thus is broader than 1227.
That's the argument, Judge Callahan. So a response to that, and I want to highlight why OB80 does not involve anything like the type of attenuated risk that they describe. One, that language, the sort of may be likely to endanger, I think this is just a common parlance problem. When you say risk of endangerment, well, the word endangerment itself is to place somebody at a risk of harm. So when you say risk of endangerment, yes, technically that is literally a risk of a risk, or may be likely to endanger. And yet, that's the language you see when describing all of these, almost any one of these state criminal statutes. That's just what it means. They're not trying to create this sort of attenuated 2 levels of risk removed from the harm. But you don't need to believe me. You can look at what Oregon has said in interpreting this very same statute. So in cases like OB80, it says a risk of likely harm is exactly what the case said. And then perhaps most succinctly was the Savage case that we cited in our brief, in which, again, it said this statute can only be satisfied by proving beyond a reasonable doubt that you created a risk of likely harm. So the attenuated risk or risk of a risk argument, we think, just fails right out of the gates. Now, on the circumstances of OB80, just to be very clear, this is not the way that petitioner described it. It wasn't just walking into the store while you were, to get diapers while the child was in the car. This was leaving your child in the car in a high-crime area for 30 minutes while you walked into a store where you could not see the child. And the court went out of its way to describe all of the particular types of harm that could have befallen the child. 2 children. There was a 1-year-old and a 3-year-old. And the reason all of this came to anybody's attention is because somebody saw the 3-year-old reaching out of the window, which had been left open, to try to open the door from the outside and almost fell out of the car, which led the mother in that case to concede that they had met. The 3-year-old had met the standard, and they were just challenging as to the 1-year-old. And the court specifically said you could have an abduction, you could have an assault, you could have somebody just opening the door and the 1-year-old falling out of the car seat because the 3-year-old could unbuckle themselves like the 3-year-old did for themselves.
So can I take this to a higher level and get your response? So I think everyone is agreed, and it's certainly been part of the jurisprudence of the Supreme Court of the United States, that absent some special function or policy, crime normally means an act intentionally taken, mens rea, evil thought, evil act, mens rea and actus reus. States and even the federal government at times have said that where it's unintentional but so risky to society, as in the case of child abuse, child neglect, or classically in the Park case, adulterated food, we will allow criminal penalties to be imposed even when there was no conscious intent, in order to encourage an extreme care. That's the ultimate purpose, is to encourage extreme care. But now, that's fine. The guy gets convicted of a crime, even though hypothetically no intent, because of that greater risk. But now Congress says if he commits the crime of such, he gets deported, a further consequence. And that certainly would not be a factor in encouraging greater super compliance to avoid negligence. It's a different kind of consequence. And so my question is, when they use the term crime there, it doesn't seem to me that Congress was thinking about the super deterrence effect that is present in the underlying gross negligence type of criminality, but they were thinking of just ordinary meaning of the word crime, which would include mens rea. So if you're following my very convoluted point is, what I'm saying is that the word crime, as used by Congress in this deportation context, doesn't carry necessarily the same meaning that would apply in the cases you're relying on.
Your Honor, I think if I'm understanding your question, or at least the premise behind it, I don't disagree. I think we agree completely that there are certain circumstances in which this concept of criminal negligence would be applied because you are trying to encourage certain conduct. And I think this is exactly the type of circumstance where that would extend to, or where Congress was intending to extend that level of mens rea, because you are talking about protecting the vulnerable. We know, based on matter of Velazquez-Herrera and based on the history of this statute, that it was trying to expand the criminal grounds of removal in general, and that it was trying in particular to create a comprehensive scheme to protect children from predators and from predatory behavior or from crimes that would victimize them. And so I think this is exactly the type of situation where you would read a criminal negligence statute or a criminal negligence mens rea into a statute, and that even though it is a removal ground and is not a federal criminal statute, it would have the exact same effect of extending to that level to protect the vulnerable and protect a vulnerable class. So if I'm understanding your question correctly in your premise, I think that's exactly why we think it is appropriate to define this removal ground with that mens rea.
Can you respond to your friend's argument that, at least under the Collins concurrence, the argument was that because criminal neglect almost implies negligence, but that's not a sufficient reason. Do you have a response to that?
I'm sorry, was it that it's not I thought his argument was like two things. One is that it's not ready to neglect, that the definitions
Correct.
don't
Yeah,
include that.
but the Collins concurrence kind of suggested because the term, the concept of criminal neglect clearly indicates criminal negligence is sufficient, and he's casting doubt on that analysis.
Sure. Yeah, I think there's a couple responses to that. One, I think every sentence in the brief that tried to distinguish between those two things had a lot of strain in it. I think the concept of neglect is, as petitioners themselves define it, failing a duty or a failure of care. And then the concept of criminal negligence, as they define it, is the mental state in doing that, and saying that that's different. That's the mental state in doing that. But then how do you define that mental state? A gross deviation from a standard of care. So it feels like they're two parts of the same thing, and maybe we're just talking about a noun and an adjective.
Right.
And then even there, some of the definitions for child neglect that they've cited to, the Garner's common legal usage definition, defines neglect to say intentional or negligent conduct. So we think all roads lead back to negligence here. The second part of that answer, and I assume this is part of what you were asking because they talked about the Ruan presumption. Yeah. This court has managed to define this about 1 million times in all the different panels, going back to Martinez-Cedillo and Diaz-Rodriguez panel and Diaz-Rodriguez en banc, without resorting to a canon of construction like that or an interpretation or a principle for construction like that. We don't think there's any resort to it here. I'm not even sure it applies when you're construing a generic definition rather than a federal criminal statute, which was the basis for Ruan. So I don't think we need to turn to that. We've been using the tools of construction for every other aspect of our arguments here. I think they are perfectly adequate to the task of finding the mens rea in this case.
Good.
All right, thank you for your
Thank you.
argument.
Thanks. Thank you, Your Honors. I think just briefly I want to respond to what he was saying at the end there, because I think in many ways that's the key to the case, right? Like, there was a concurrence, you joined the concurrence. Again, we agree with most of the concurrence, and it really does come down to this mens rea issue. And I just don't think there was really a response at the end of the day to these definitions that we quoted that actually go out of their way, almost unusually, to clarify the fact that neglect does not mean negligence. Neglect means that you violate a duty to care, a duty of care, right? And you can do that intentionally. You can have a kid who you have a duty to care for, and you say, I don't care about that kid. I'm going to go to the bar and drink and leave that kid alone, right? You could also do it negligently, like the woman in Obeidi. And I'm not in any way suggesting that what she did was correct or that I would do that, but it's a very different thing than making a conscious decision to violate your duty to a child. And I think that's what these definitions get at. And yes, the words are similar. They both get at violating duties, but very different duties and in very different ways. And again, two different contemporary legal dictionaries go out and say that. And the contemporary criminal codes that use the word neglect all have a mens, well, not all, but almost all have a mens rea of recklessness or higher. So I actually genuinely
But some
don't.
states do have negligence, right?
Absolutely, and we're not saying there's anything inconsistent about like you definitely can be negligently neglectful.
Right.
But again, these definitions that aren't talking about just the criminal law; they're just talking about in general. So I think our point isn't that you can't have negligent neglect. It's that you can have neglect with any mens rea, and so you have to apply other tools to try to understand what the crime means. And I think that's why Ruan is helpful. And Ruan isn't some kind of like, ambiguity resolving canon. It's just talking about what the word, how we understand the criminal law. And so when you have a provision that is focused on crimes in general, you don't think that what it's talking about is negligent conduct. You think it's talking about intent or at least knowledge. I see my time has expired, but thank you very much.
Thank you both for your argument. This matter will stand submitted.